Delta farmers are suing a Missouri bank that seized their harvest. Farmers say UMB Bank kept express grain elevators open through harvest, knowing the company was teetering on financial ruin. Once the silos were full, the bank seized the harvest as collateral for $70 million in loans. Roger McEowen with the Washburn School of Law joins us now to review some key takeaways in today's Rural Money segment. Roger, good to have you with us. Let's start with a recap of the matter and kind of the facts about this case.
Well, you're right, Tammy. It was on November 8th that there was a group of Mississippi farmers that did file a class action against UMB on the basis that the bank misled them about the financial status of the grain elevator that they had sold their fall harvested crops to. And they were doing that on a deferred basis. They knew they weren't going to get paid at the time they delivered the grain. The case filing is not clear as to whether they had deferred payment contracts or not. It's just clear that they knew they would not get paid at the time that they delivered. And that brings up the really key point, and that is anytime you deliver grain to an elevator and you don't get paid on the spot, you become an unsecured creditor of the buyer at any point in time after delivery and before payment is made. So if they file bankruptcy, as is happening in this instance, you are unsecured and you're probably not going to get paid anything.
Interesting. Now, is there a way that cash grain sellers can achieve security?
Well, you always have to do due diligence in these situations. You need to inquire into the financial status of your buyer. And I've suggested for years that farmers that get into deferred payment contracts and just standard deferral arrangements, whether there's a formal contract or not, demand an audit, demand to see a certified audit. You want to know the financial status of that buyer. Had that been done in this instance, they would have seen that there was some insolvency issues going on. Now, this elevator had to provide an audit within 120 days of the end of their year end, which was December 31. But by then, it's pretty much too late. So demand an audit, and maybe we can use escrow accounts and letters of credit to get around the problem of not having security if it's done correctly. Now, there are court cases on this. There's a right way and a wrong way to do it. But if you're careful, you might be able to use a letter of credit or an escrow account, hold those funds separate from any subsequent bankruptcy estate, have those put into that escrow account, not draw on that until the next year. You get your deferral status for tax purposes, and you might have protection from a failed buyer. None of that was done in this instance.
Well, what would be the big takeaway for farmers from this?
I think that's just it, Tammy. You've got to be talking to your attorneys, understand what state law is. The state might have an indemnity fund or a bonding program. Now, usually those funds are woefully inadequate to compensate one farmer, let alone a bunch of farmers. But have well thought out procedures to provide yourself security in the case that buyer goes belly up, because you are unsecured. And that is very, very important. Talk to your attorneys in advance. I know farmers don't like to do that. They think this is just the standard way we do things, but this points out the peril when things go bad.
Yeah, got to do that due diligence. That's Roger McEowen with the Washburn School of Law. Appreciate your time today.